She walked into my courtroom carrying an oxygen tank, not for effect, not to generate sympathy, because without it, she could not walk 30 feet without stopping. Her name was Evelyn Marsh, 73 years old, stage 4 pulmonary fibrosis, a condition that, as her pulmonologist had noted in the medical summary attached to her filing, had a median survival window of 18 months from diagnosis. She had been diagnosed 11 months ago. She had 7 months, statistically, maybe less. She had spent 2 of those 7 months building this case, and the man she was suing sitting across from her in a suit that cost more than most people make in a month, not even looking at her, scrolling something on his phone while she settled into her chair, had 3 weeks earlier, in a recorded phone call that his own assistant had unknowingly left running, called her a, quote, desperate old woman trying to squeeze money out of me before she croaks. His name was Derek Holt, 47 years old, founder of a property development company with assets valued north of $90 million. And he had no idea what was about to happen to him in my courtroom. Neither did I, entirely. But I suspected. I will tell you this. By the time I struck the gavel that morning, there was not a dry eye in the room. Not one. And the last person standing, the one still fighting tears when everyone else had already given in to them, was me. Stay with me, because this story starts with a garden. Evelyn Marsh had lived in her house for 41 years. She had moved in as a 32-year-old with her husband Gerald and their 2 young daughters, when the neighborhood was still developing, when the streets were still being paved and the houses were being built in the kind of modest, careful way that people build homes they intend to stay in for a lifetime. And she had stayed. Gerald had died 17 years ago. The daughters had grown and moved and built their own lives. Evelyn had stayed. The house was paid off. She owned it outright, had owned it outright for 9 years. The mortgage retired with the same quiet discipline that had characterized everything about the way Evelyn Marsh moved through the world. She maintained it herself where she could, hired help for what she couldn't, and spent a significant portion of each day in the garden she had built along the eastern side of the property over 4 decades. Roses, hydrangeas, a clematis that had taken 12 years to train along the fence properly, and that was, by every account of every neighbor who had mentioned it in the character statements Evelyn had collected, the most beautiful thing on the block. 3 years ago, Derek Holt's company had purchased the vacant lot adjacent to Evelyn's property. He had not introduced himself. He had not sent a letter. He had not done any of the things that a person does when they move into a neighborhood and understand that neighborhoods are ecosystems of people who have been there longer than you and whose history with the space matters. He had sent a construction crew. The construction crew had begun site preparation for a 12-unit residential development. Standard equipment, excavators, graders, compactors, the machinery of development, which is loud and heavy, and when operated adjacent to a 41-year-old garden, catastrophic. The vibration from the compacting equipment had, over a period of 6 weeks, destabilized the root systems of plants that Evelyn had spent decades cultivating. The clematis along the fence, the one that had taken 12 years to train, had been the first to go. The fence posts it depended on shaken loose by equipment that came within 4 feet of the property line. The roses followed. The hydrangeas, whose root systems were shallower than Evelyn had realized, died within a month of the compaction beginning. By the time the construction crew finished site preparation, the eastern garden was gone. Evelyn had filed a complaint with the city. The city had reviewed it and found the construction within permitted parameters. She had written to Derek Holt's company twice, both letters unanswered. Then she was diagnosed. She was not going to let this go, not because the money mattered, because 41 years of building something beautiful deserves to be acknowledged, because she had 7 months and she intended to spend part of them making sure A consequence happened. Derek Holt arrived 11 minutes late. I noted it. I note everything. He arrived with 2 attorneys and without an apology. Expensive without being formal. He sat down without looking at Evelyn Marsh. Not once. She was 5 feet from him with an oxygen tube in her nose. He did not look at her. I noted that too. His lead attorney, a woman named Patricia Vane, who had 22 years of civil defense experience and who I had seen in my courtroom before on different matters, rose and presented the standard opening. The construction had been properly permitted, the work had been conducted within legal parameters, the alleged damage to the plaintiff's landscaping was not attributable to Derek Holt's company with sufficient certainty to establish liability, and any claim of emotional distress connected to the loss of garden plants was speculative and unquantifiable. It was competent. It was the argument the facts available to her allowed. Then Evelyn Marsh's attorney stood up. He was Christopher Alade, 26, 2 years out of law school, who took this case because Evelyn walked into his office and he said yes. Not yes if the numbers work out, just yes. He submitted 3 exhibits. The first was a horticultural assessment from a certified arborist who had documented the damage to each plant individually, established the probable cause as construction vibration consistent with heavy compaction equipment, and calculated replacement value not of the plants as commodities, but of the plants as mature specimens that had taken decades to reach the state they were in, which is a legally distinct and substantially higher number. The second was a documented communication record, Evelyn's 2 letters to Derek Holt's company with delivery confirmation and the complete absence of any response. The third was a transcript of the recorded phone call, Derek Holt's voice, his assistant's voice, the specific words spoken when Holt believed no one who mattered was listening. Patricia Vane requested time to review the third exhibit. I gave her 3 minutes. When she sat back down, something in her posture had changed. She was still composed, but she was also, I could see it clearly, recalculating, rapidly. I asked Derek Holt to take the stand. He sat down in the witness area with the studied ease of a man who has given depositions before and knows how to carry himself in formal questioning. Relaxed shoulders, measured pace, the body language of someone performing competence. He crossed one leg over the other. He looked at Christopher Alade with the particular expression of someone who has already decided the other person is not a worthy opponent. Christopher Alade asked him one question to open. He said, "Mr. Holt, did you receive either of the 2 letters Miss Marsh sent to your company in the 18 months following construction at the adjacent property?" Holt said, "My company receives a significant volume of correspondence. I couldn't speak to every individual letter." Christopher said, "These letters were addressed to you personally, by name, at the corporate address listed on your permitted construction filing. They contained return receipts. Both were signed for." Holt said, "If they were received, they would have been processed by my administrative team." Christopher said, "Processed, meaning what?" Holt said, "Reviewed, categorized, handled appropriately." Christopher said, "Handled appropriately. And what would appropriate handling look like for a letter from a neighbor describing property damage your construction had caused?" Holt said, "I would expect my team to assess whether the claim had merit." Christopher said, "And if they determined it had merit?" Holt said, "They would have followed up." Christopher said, "They did not follow up. It was not a question." He let it sit in the room as a statement of fact. Holt adjusted the position of his crossed leg, his first visible physical tell, and it was small, but I had been watching him for 20 minutes by then, and I noted it the way I note everything. Christopher said, "I'd like to play Exhibit C." Patricia Vane said, "Your Honor, we object to the use of this recording on grounds of," I said, "overruled." The recording was made on a device your client's company operates, during a call your client initiated, in a context where all parties to the call or employees of or contractors to your client's organization. Play it. The recording lasted 47 seconds. In those 47 seconds, In Derek Holt's own voice, at his own cadence, he described Evelyn Marsh's complaint as a shakedown by a desperate old woman trying to squeeze money out of him before she croaked. He said the word croaked. He said it without hesitation, without particular emphasis, the way you say something you believe so completely that it doesn't require dressing up. The courtroom gallery was very still. I looked at Evelyn Marsh. She was looking at the table in front of her. Her hands, which had been resting flat on the surface, were now folded. Her oxygen tank made its small mechanical sound beside her chair. She had heard this before. She had prepared for hearing it again. But preparation and experience are not the same thing, and I watched her absorb it a second time with the quiet, contained dignity of a woman who has decided that this is what it costs to be in this room, and that the cost is worth it. I looked at Derek Holt. He was looking at the recorder on the evidence table. His crossed leg had uncrossed. I said, "Mr. Holt, is that your voice?" He said, "Yes." I said, "Is that an accurate representation of your view of Miss Marsh's complaint?" His attorney was on her feet. She said, "Your Honor." I said, "Sit down, counselor. I asked your client a direct question. Mr. Holt, is that recording an accurate representation of your view of Miss Marsh's complaint at the time that call was made?" A long pause. He said, "It was a private conversation. I was frustrated. I may have expressed myself in a way that doesn't reflect." I said, "I didn't ask how you expressed yourself. I asked whether that expression was accurate. Were you, at the time of that call, of the view that Miss Marsh was and I am quoting directly,